We are staying with development in Kano State, where a federal high court sitting in Kano has ordered the eviction of Emir Muhammadu Sanusi II from Kofar Kudu Palace. The court also ordered the police to ensure all rights and privileges due to the 15th Emir of Kano, Aminu Bayero, be given to him. The presiding judge, Justice S.A. Amobeda, who gave the ex-parte order, stated that the order is made in the interest of justice and maintenance of peace in Kano State. The order restrains the third, fourth, and fifth respondents and all other respondents from denying the applicant to use his official residence at the Emir's Palace, Kofar Kudu, as well as enjoyment of all rights and privileges accrued to him by virtue of being Emir of Kano State. The order also evicts anybody residing within the palace illegally, pending the hearing and determination of the originating summons. The suit has been adjourned to the 4th of June for hearing. Earlier, the Public Relations Officer of the Nigerian Bar Association in Kano State, Ibrahim Baba, spoke to TVC News on the issue. And joining us is a lawyer, Bolanle Odugbani. Thank you so much for joining us on TVC News at 10.
Thank you. Thank you for having me.
All right. What is the legal implication of these conflicting orders from the Federal High Court and the State High Court, Court of Competent Jurisdiction, on this Emirship crisis?
So the Federal High Court and the State High Court are courts of coordinate jurisdiction. That is, they are on the same level in the hierarchy of courts in Nigeria. The Federal High Court has the jurisdiction under Section 251 of the 1999 Constitution to cater to certain subject matters. The subject matters listed include arms and ammunition, the central bank coinage, currencies, aviation, and all such other subject matters. So none of it has chieftaincy or emirship listed in Section 251 as being part of the subject matters that the Federal High Court has jurisdiction over. So it becomes more intriguing that, such an order can emanate from the Federal High Court. But I dare say that it is possible that the Federal High Court assumed jurisdiction by way of the possibility that the application that was filed was one that had to do with fundamental human rights of the deposed emir. The State High Court, has a wide jurisdiction on all subject matters, including claims relief for all civil causes, including the emirship and the chieftaincy matters. So that's the court with the appropriate jurisdiction. So if the Federal High Court has jurisdiction, it's probably for the enforcement of the fundamental rights of the deposed emir. The State High Court, giving a decision that appears to conflict with that of the Federal High Court, they have done so, because it has original jurisdiction to do so. Now, the conflict, how can the conflict be resolved? It's a serious problem for the judiciary in Nigeria, and I think that it is high time that there's a form of registration of court orders and court judgments within the judiciary, such that any judge who wants to inquire as to the subject matter, either by way of checking through the types of litigants who filed applications or any other way by which an order made by any court of coordinate jurisdiction, can be inquired upon by a court that handles a fresh matter, so as to avoid this type of conflicts in orders and decisions by this type of courts.
What do you recommend as a way out of this confusion, really? Is it the legal route or some kind of political solution?
Well, the courts essentially interpret the law, and as such, the Constitution and indeed the legislature at the level of the National Assembly and indeed the House of Assembly should have a say by, making laws that regulate this type of judicial confusion, so that if the National Assembly makes a law that mandates or compels that there should be some form of registration of orders by all courts of coordinate jurisdiction to avoid these conflicting orders being made by, courts of coordinate jurisdiction. I think the problem will be easily solved. Any judge that has a matter can use the names of litigants to check up whether an order has been made within the last 24 to 48 hours, and so they avoid, making a conflicting order. They can also, use the subject matter, as in this case, Emirship, to say Emirship Kano, Emirship Kaduna, Emirship Obaship Lagos, to say whether, they can avoid having these conflicting decisions. Once it's an order made by a court of coordinate jurisdiction, no other court of coordinate jurisdiction should be making an order on the same subject matter with the same kind of litigants before it.
All right, Mr. Olugbani, thank you very much for sharing your thoughts with us. I've been speaking with Bolanle Olugbani, a lawyer. Thanks a lot for talking to us on the news at 10.
Thank you.